You are listening to the Marc Guzman podcast experience. Welcome to another episode of the Ask Marc Anything. So today I want to do a little bit of a different episode. I am in Long Beach. We just finished the California Association of Realtors REImagine Expo and fall meetings. It was a really fun event. The REImagine Expo, I have to say, was very impressive. They, instead of doing it like a traditional expo like they've done in the past, they decided to do an expo plus a TED Talk style event. And it was 3 days. It was amazing. They had, I want to say, over 125 different speakers. They had over 200 different vendors at the expo. They had a lot of different events going on. It was really amazing. And in addition to that, they also had the fall 2018 office meetings where, as an association, the directors get together through various committees and work together to figure out solutions to the current housing problems. And so I want to give everyone a quick legal update on what's been coming up as far as new laws, what's died as far as new laws. If you follow my podcast, hopefully you listen to the legal updates I provided for you from Sacramento. Sacramento 2018 was done back in, I want to say early May, around Cinco de Mayo. So I actually did 2 episodes back then, a part 1 and part 2, because there was a lot to talk about. This time it's only going to be a part 1 episode series, because I'm going to be able to go through various laws that died or that got signed into law. So let's just go ahead and jump right into it. So the 2 big propositions on the ballot for California 2018 in November, just in a few weeks, we'll talk about the first one, which is Prop 10. Prop 10, you've heard me talk about it on the podcast multiple times, but Prop 10 would remove the Costa-Hawkins bill that was enacted in 1995. Now, what Costa-Hawkins does is it prevents single-family homes, condos, and townhomes from being under rent control in cities that have passed rent control. This is really important because at the end of the day, rent control simply does not work. It limits the supply and it creates much higher rental prices simply because it encourages people to stay in their properties. Thus, the actual normal supply on the market gets reduced. Simple supply and demand. So Prop 10, if you vote yes toward Prop 10, that would eliminate Costa-Hawkins. Now, another thing that Costa-Hawkins also allows is vacancy decontrol. So let's say, for example, you're a property owner and you buy an apartment building and the apartment building's under rent control, and let's say unit number 1 is renting at $1,000 per month. Well, as of today, with Costa-Hawkins in place, if that tenant leaves the property, you as a landlord can then raise that to market. And let's say market rate might be $1,500. Well, knowing that you're going to get an extra $500 a month, you're typically, as a landlord, going to repaint it, possibly do new carpet, some upgrades, knowing you're going to get this additional rent because you're now taking it to market. Well, without Costa-Hawkins, it allows for cities that have rent control to place restrictions on how much you can increase it when it's going back on the market. It essentially wipes out the vacancy decontrol factor. So, as an example, that same tenant renting at $1,000 a month decides to leave. They leave the rental. You may be limited and restricted to how much you can place that rental back on the market. There's some cities that talk about there should not be an increase when putting it back on the market, meaning you might be renting out that same apartment for $1,000 a month. Well, let's say it needs carpet and paint and several other upgrades. What's the likelihood of a landlord doing any cosmetic updates? Probably very, very little chance that they're going to spend a lot of money knowing they're not going to get any of that investment back. So I don't recommend to vote yes on Prop 10. In fact, Prop 10, you should vote no, because by removing the Costa-Hawkins, it's going to be very detrimental for property owners in the cities that already have rent control. The other prop that's going to be on the California ballot is Prop 5. This is the tax portability initiative that was really sponsored and created along with the California Association of Realtors, and this essentially mixes Prop 60, Prop 90 together. So to give you a quick rundown, most of us know Prop 13, in which it keeps your tax rate set at a certain level, which is 1% of the assessed value. Your assessed value can only go up so much every single year. Now, what Prop 60 does is if you decide to sell your property and purchase another property of lesser value in the same county, you can move your tax basis to that other property, to that new replacement property. Now, of course, this only applies for your personal residence. So that's Prop 60. Prop 90 allows for participating counties where you could sell in one county, buy in another county, and move your tax basis to that new county. Now, the problem with Prop 90 is that only 11 out of 52 counties actually participate in the program. So there's not a lot of people that can really take advantage of that. With that said, Prop 5 has been created and it's going to be on the ballot for the voters, and you want to vote yes on Prop 5. Now, with Prop 5, what this does is it combines Prop 60 and 90 essentially, and what it allows is for senior citizens to move and sell from county to county throughout the entire state of California. So it forces the counties to participate in essentially in that Prop 90 program. But there's also a few other features, and it allows you to buy up and buy down. And we highly recommend this because it's just really going to help a lot of people. There's a lot of cases where you may have someone selling in a high-end area or high market value area that wants to downsize and move to a different area and move their tax basis. And that different area might be a cheaper, low-cost area. Or you may have it vice versa, but you have a lot of people that want to live closer to their kids, grandkids, whatever the case may be, but they simply can't because their Prop 13 taxes are really low. And if they move to another county that doesn't participate in Prop 90, now they're going to be stuck paying normal taxes that are much higher. So this is going to help encourage approximately 45,000 homes to come onto the market every single year. So with that said, it also helps putting more inventory, more supply on the market that will help alleviate home prices and allow more properties to be sold, giving buyers opportunities and more chances to, your everyday buyer to buy something, because we all know it's very competitive right now. So those are two big propositions that are going to be on the ballot. So right now I want to talk about various different laws that died or passed, and I'm going to go through this pretty quickly. So if you have any questions about any of these laws, please feel free to send me an email. You can send it to Marc, Guzman, Guzman, at bgam.us. Feel free to send me an email with any questions, and I'd be more than happy to help you as much as possible. So the very first one is AB 2219. So Assembly Bill 2219. What this bill, to give you a little background, there was a case down in Southern California where a landlord denied, I believe it was a landlord, it might have been, it was a landlord that denied a veteran rental housing, because their source of income was subsidized from the VA. Well, the veteran countersued for discrimination against source of income, and they won. And it was determined that you cannot discriminate against source of income, but it was a very vague ruling. And so they wanted some additional clarification, because that ruling would also potentially require landlords to be forced across the state of California to accept Section 8 funding. But there are issues with Section 8, and I've done podcasts before regarding Section 8. Now, in full disclosure, I'm a fan of Section 8 and highly advocate and recommend most landlords to accept it because there are many, many benefits to Section 8. And so, but it is a voluntary program. So this ruling, the fear was that it was going to force landlords to accept a lot of these different subsidized programs that are all voluntary. So AB 2219 simply came out to clarify that Section 8 does not fall under a category of third-party payees. And what this assembly bill does is it makes it illegal to discriminate against third-party payees such as religious organizations and some other charities that can help provide subsidized housing or one-time payments. So going forward, as a landlord, if someone comes to you, and I just did this recently with Catholic Charities Organization of the East Bay, if they come to you from a religious organization or some other charity program to pay rent, whether it's 1 month or 12 months, you cannot discriminate against that. So now Governor Brown signed that into law that third-party payees are allowed. However, Section 8 does not fall under that third-party payee. Assembly Bill 2343. This goes into effect on October 1st, 2019. What this does is it changes the counting days for 3-day notices, 30 and 60-day notices when you give it to a tenant. So where this is really coming into play and where it's going to make a difference is in the 3-day notices. So for example, you're a landlord. Your tenant does not pay you rent on the 1st. They have a 5-day grace period. They don't pay you rent by the end of the 5th-day grace period. So you serve them a 3-day notice on day 6. Well, today, how it works is, let's say you serve a 3-day notice on a Friday. Friday becomes day 0, Saturday day 1, Sunday day 2, Monday day 3, and on Monday is their very last day to pay you rent. On Tuesday, if they have not paid rent, at that point, you are now legally allowed to move forward with an eviction. Now, what AB 2343 does, and it's already been signed into law by Governor Brown, again, it goes into effect October 1st of 2019. What this does is counting days, the way I just gave you in that sample, weekends were counted. What this new assembly bill does, it eliminates being able to count weekends and holidays, and you can only count court days. So, for example, if you serve a 3-day notice on Friday, that Friday would be day 0. Day 1 would be on Monday. Day 2 on Tuesday. Day 3 on Wednesday. So it's essentially giving the tenants like a few extra days to pay rent once they've received that 3-day notice. The argument behind it is that sometimes, especially with management companies and professional organizations, if a tenant gets a 3-day notice and they have the money to pay, let's say on a weekend or a holiday, well, that company or organization is not going to be open. Sometimes the landlords are not available to accept rent. So in a way, it's not fair to the tenant because it becomes more difficult for them to pay rent on a weekend if the place of business is not open. So what this bill does is it just simply states you can only count calendar days, you can only count business days, aka court days. AB 2618. This is a bill that recently died and did not get signed in. What this bill does is, or what this bill proposed, was that every property manager, every property management company, and every landlord, regardless if you're a licensed real estate agent or not, so this is every big giant corporation that owns rentals down to your mom and pop that might only own one rental property. This bill would have required for everyone that owns rental property or manages rental property to take classes to become certified in proper ethics in property management. So this bill died because how would you enforce so many landlords that individually manage their properties? How would you enforce them getting certification who would do the training. It was a very vague bill, and there was not a lot of details into it. And then on the real estate side, we already have to follow certain code of ethics. If we're a realtor, we are regulated by the Department of Real Estate. We already have to take a lot of these classes. So it's kind of doing it all over again, just for no specific reason. So that bill died very quickly. There was another bill, Assembly Bill 2925, and this would put just cause eviction across the entire state of California. Typically, you see just cause eviction ordinance tied into rent control and in cities that have rent control. However, this bill would have placed it across the entire state of California, and this bill died fairly quickly. Senate Bill 1427. This is another bill that kind of tied back to Assembly Bill 2219 in that it would partially make it mandatory that landlords have to accept Section 8 under certain conditions. This bill died. It's Section 8, simply put, is a volunteer program. There is a new ruling that came down from the Fair Employment and Housing Department, and they determined that you are allowed to screen and deny tenants based on criminal history. So this was a debate that's been happening recently, in that people were being denied for criminal history and they were suing for discrimination. And some people, there's not really rules on denying people for criminal history. However, as a landlord, you're liable if you place someone in a property that may do harm to other tenants or even to neighbors. So to give you an example, if there's a very violent felon or history of violent criminal activity or drug dealing or a sex offender, and you place them in a building that they may do damage to other tenants, you as a landlord are liable if you knew about that. So when screening a tenant, most landlords are going to do some kind of criminal background check. And if something comes up, it is a landlord's responsibility to keep their current tenants and future tenants safe. And so this really has been an issue for the last several years, and it was pushed up to the Fair Employment and Housing to make a ruling decision. So they came back and said, you are able to deny based on criminal history. But however, it's still advised before you deny someone on criminal history to talk to a real estate attorney, because you cannot deny just because someone has criminal history. If you're denying someone because they stole maybe some sodas 10 years ago from a 7-Eleven store and got a small misdemeanor and fines, that would not fly. That would not be legit. But if you deny someone because they're a sex offender and your building has children in it, that might have legitimate reason behind the denial. So before you deny anyone, you always want to run it by a real estate attorney. Also, that was sent up to the Fair Employment and Housing was the decision on service animals. So the Fair Employment and Housing came back with several rules. There's been several bills that people have tried to pass to clarify rules in California regarding assistive animals. Now, just to give you a quick breakdown, when you have an animal, if there's different classifications, there's service animals, which are professionally trained for people with a disability, and they're licensed, certified, professionally trained animals. Okay, there's no one trying to deny that, and you cannot deny and discriminate against someone that has a service animal. However, what has been an issue in some cases are the emotional support animals, the assistive animals, the comfort support animals. These animals, there's been a lot of debate, and the biggest question is, does the tenant really need these comfort support animals, or are they just using this as an excuse to have an animal in the building? So there hasn't really been any rules. However, there's been rulings upholding the fact that if a tenant approaches you and they have documentation, and there's various ways to document it, but if there's documentation or some sort of proof that they have a disability and that this animal is their comfort animal, you cannot discriminate as a landlord. But in some cases, it's extremely hard to tell if someone has a disability. And one of the biggest problems is that you can go online for $50 or $100 and just purchase a certificate without entering any information about yourself or your animal. And so is that even right to do? So all that was sent up to Fair Employment and Housing. They came back with a ruling that, and let me read this here, but they came back and said a support animal certification from an online service that lacks an individualized assessment from a medical professional does not constitute sufficient verification to show the need for the animal in the unit. So this is going to change those automated websites where you can simply print out and pay for $50 and get one of the certificates showing that your animal is a comfort animal. So that change is coming up, and Fair Employment and Housing has made that change. AB 1919. So this is recently signed into law, and what this states is a landlord cannot increase the monthly rental price for rental housing by more than 10% for 30 days after a state of emergency has been declared by the president, the governor, or local official. So if there's a state of emergency, and in California right now there is a state of emergency that was renewed back in April, but what this states is once the governor, for example, declares a state of emergency for whatever reason. Recently in California, we had the California wildfires. A state of emergency was issued because of that. When that happens, for 30 days, if a landlord wants to raise rent, they cannot raise it more than 10%. After the 30 days, my understanding is there are different rules that may or may not allow you, depending on the state of emergency. So if there's a state of emergency, before you raise any rents, what you want to do is contact your local real estate attorney and verify your situation, your county, your area, and see what would be appropriate if you wanted to raise it by more than 10%. We have Senate Bill 721, which was signed into law, and it goes into effect technically by 2025. So what Senate Bill 721 is, and to give you a brief history, if you remember back in several years ago, Berkeley, California, there was a house party. There were students on the balcony, and the balcony collapsed and several people died. Very unfortunate event. That spurred a lot of investigation into what happened, and what was discovered was that the balcony was rotted. There was a lot of damage to the balcony, and that if it was fixed or caught ahead of time, these deaths could have been prevented. So several cities around the state have already passed their own versions of this bill, but statewide it made it up and it got signed into law. So it's Senate Bill 721, and how it's it's going into effect, and I'll break it down for you here. So this would require an inspection of 3 or more units with balconies, walkways, and other elevated building structures. So for example, if you have a fourplex where maybe 1 or 2 units are on the bottom, 2 units are on top, and you have a walkway or a balcony or patios, basically balcony, anything that's elevated where tenants can be walking, that would require an actual inspection of that walkway. Now, the law was amended to include the following. It limits the scope of inspection to 15% of the elements of wood-based balconies and walkways once every 6 years. When this bill was initially proposed, one of the big issues was that it would require at least 25% or a third. But the type of inspection, in order for you to inspect the wood-based balconies and find exactly if there's damage, is to actually break into it. So it's a destructive inspection. So they changed it and modified it to where you would only have to destroy approximately 15% of the elements in order to inspect it. Then you would have to, of course, repair that 15% that you damaged, but you would have to do this once every 6 years. HOA developments are not required to comply with this law. They are exempt. Landlords can choose inspectors. One of the fears was that there would be a list of licensed inspectors throughout the state of California that would limit various people to choosing vendors on this list. And of course, the fear would be because the list would be very small, they would be charging high inspection prices. But they did modify that to include that landlords can choose their inspector. The initial inspection must be done by 2025. So your very first inspection you have from the end of 2018 to January 1st of 2025. Now, initially when this bill was proposed, it says you had to do the inspection every 3 years. So now it got changed to every 6 years. But it also said that you had to keep a copy of every inspection report on file. And it had no definite time period. So it was literally unlimited. As long as you own the building, you need to have a copy of all these different inspections. This was modified to only include the most recent 2 inspections. In addition to that, the Senate Bill 721 was modified so that it provides a compliance period, because once you find out there's damage, you have to get permits, you then have to get the work done, and that can take a lot of time because you're dealing with a very complicated permit process in some cities, or you're dealing with a very complicated repair that takes time. Or in another issue in California, there's just a lack of contractors that have time. So sometimes you have to book it 3 or 4 months out in order to get the repair done. So this Senate Bill 721 provides a compliance period of 120 days for permit applications and another 180 days from the permit approval to actually make the repairs. So those were a lot of the bills that were signed in and that recently passed. It was very interesting conference. I also attended the Global Real Estate Forum, and that was very interesting to attend because they had an immigration attorney, and I believe his name was Paul Chung from San Diego, I believe. And he provided some very interesting information on the difficulties today for Chinese immigrants coming to America. And it has nothing to do with the current presidency under the Trump administration. A lot of these changes were done under the Obama administration. However, due to a lot of fraud that's been happening under EB-5 immigration rules, the actual immigration department is cracking down on it, and they're becoming stricter in their own policy. So they're creating policy changes that are making it tougher for people to come into the United States. With that said, a lot of these people going through that process are using the purchase of real estate as a way to get into the country. But now with that difficulty, or with the immigration department cracking down on a lot of loose, I guess you could say, not loose ends, but like a really loose law. They're cracking down and really making it stricter and harder. What's happening is a lot of these people that would normally be buying real estate are not buying real estate. And you're seeing that right now in the market shift, in that there's a few less buyers and there's more inventory coming on the market. Then they had another speaker, and I forget his name, but he was a commercial broker also from Southern California, I believe Los Angeles. But he provided some very interesting statistics and showed us how many of the foreign Chinese or Japanese corporations that buy large development projects to develop, like they buy big chunks of land, build hotels, commercial buildings, residential apartments. What they're doing is, instead of developing, they're now stopping their projects and putting everything up for sale because of the conversion rate to the currency in China and Japan. And what's happening is they're literally selling the properties to take the money back, because just simply taking the money back, they're going to make billions of dollars. I mean, we're talking about billions and billions of real estate. So with that in mind, we're starting to see a move of foreign buyers disappear from the U.S. simply because of immigration rules and because of dollar conversion rates. So a very, very interesting forum, in where they gave a lot of insight into why the real estate market is doing what it's doing today with the market shift. So it was a very good conference. I'm still here in Long Beach. Everyone in the conference has basically left this morning. I'm staying around for one more day, doing a little bit of work, enjoying Long Beach, and then I'm off to Vegas. I am getting my certified property manager designation, which will be very fun and educational. We'll be in Vegas for 9 days. It'll be a very long time in Vegas. Not sure if I should be looking forward to it or not. I've been to Vegas many times before, and typically after 3 days, that's more than enough for me. So it'll be interesting to be there for 9 days, but it'll be very informative classes. I'm looking forward to it, looking forward to meeting new people. And so if you have any questions regarding property management, regarding one of these bills, keep in mind, I am not a real estate attorney, but feel free to reach out to me depending on your question. If I can answer it, I will. If not, I will put you in touch with a really good friend of mine who's our real estate attorney, who will give you advice depending on your situation and can help you answer those questions that only an attorney can answer. So thank you again for listening, and make sure to subscribe and rate and review my podcast. We've been having a lot of great reviews verbally in person. I've met quite a bit of listeners just catching me here and there here at the conference. Also when I'm out and about in the Bay Area. Really, really thank you for listening. The great feedback, but please go subscribe and give us a rating, and thank you for listening.
Thank you so much for listening to the podcast. Thank you to our producer, Sam Lubman. Please subscribe, like, comment, and share the podcast. Remember, you can listen to the podcast on iTunes, Podbean, iHeartRadio, Google Play, SoundCloud, and anywhere else you listen to podcasts. For more information on my business as a property manager and real estate team, go visit my website at markguzman.com. I really want to thank all of you for listening. It means the world to me, and I hope today's episode provides you value in your day-to-day life. I created this podcast to help showcase the many great people that live in this world and help share some knowledge that I've learned along the way in life. Again, thank you for listening. Check out our sponsors, and I'll catch you on the next episode.